one.
Good evening, everyone. My name is Jacob Baychalk. I am an attorney here at the Legal Aid Society of Palm Beach County in our Rapid Response Eviction Assistance Program. And I am joined by a colleague of mine who I will let introduce herself.
Hi, good evening. Amory Puente, also an attorney at Legal Aid with our Rapid Response team. And we welcome you to part of our Tenants' Rights Week presentation, what to do if you are served with a writ of possession.
All right, so let's go ahead and get started. A little bit of background about us, the Legal Aid Society of Palm Beach County. We are a nonprofit charitable law firm that provides high quality civil legal advice, representation, and education to the disadvantaged children, families, elders, and individuals residing in Palm Beach County so as to protect their personal safety, enhance their opportunities and living conditions, and help promote self-sufficiency. And here at the Legal Aid Society in Palm Beach County, we serve over 8,000 clients every year. So we're going to start with a little bit of the basics. What exactly is a writ of possession? What does that mean? What is the law behind it? What does it mean for you practically? We'll get into all of that. But basically, a writ of possession is a court order granting possession of a dwelling back to the owner or landlord. So typically, this is nearing the end of the life of an eviction case. You have a complaint, you have a response to that complaint, you may have various hearings, and then once there's a final judgment of eviction, if the case reaches that point, the next step is that you are served with this writ of possession. If the sheriff posted a writ of possession on your dwelling, that serves as a notification that you have 24 hours to vacate both yourself and all of your belongings from the dwelling. If you're still there after the 24 hours, the sheriff may come back and forcibly remove you and your belongings. And this 24-hour period also includes weekends and holidays. The specific Florida statute regarding the writ of possession comes from section 83.621, and that reads, in an action for possession after entry of judgment in favor of the landlord, like I mentioned before, that final judgment of eviction, the clerk shall issue a writ to the sheriff describing the premises and commanding the sheriff to put the landlord in possession after 24 hours notice conspicuously posted on the premises. Saturdays, Sundays, and legal holidays, as I mentioned, do not stay the 24-hour period. Oftentimes, we'll have an example a little later on. The writ of possession can be served or more often posted on the property. And we'll show you what that looks like here in a little bit. So how did I get here?
Yeah, so how did we get here? So just we've had probably some webinars on these issues, but just to let you know that, of course, like Jacob just spoke about, the eviction process, which is part of that, really gets the gears in place. That's why there's gears here. And then you have that final judgment and writ that's part of the court clerk's process. And then they issue that writ and they send that writ actually to the clerk. To the sheriff, clerk to the sheriff. And then the sheriff then really is the one that executes on this writ to the tenant. We have this little sand timer here because all of it is all about timing, and all of it, the gears, which make it interesting as well, is that at each point in the process, actually, the gears could actually get stuck and actually can pause a lot of the timing, but it's important to understand these pieces. So what can I expect when I'm served with a writ of possession? And here's a little bit of from one of our neighboring counties, but this is generally how a notice will look like. The practical aspects of a writ of possession, and this is specific to Palm Beach County. We spoke to the Palm Beach County Sheriff's Office, because a lot of times you have a statute in Florida, but different counties execute and have different policies in each county. And so specifically in the county that we have, in Palm Beach County, there's three really important parts to kind of keep in mind of the practical pieces. The sheriff's office will usually bring about 2 people to your home. There'll be a red and white sticker on the door and a copy of the writ of possession that's directly from the clerk in the clerk's office. So this time frame piece is what's really important in order to make sure you know what you need to be doing. It's considered actually 24 full hours. So in many ways, it's considered a 3-day process according to our the Palm Beach County Sheriff's Office, and it could actually be up to 5 days, and we'll explain what that means. And a lot of times the time frame that they deliver, according to what they told us, is early in the morning into 3 p.m. And the reason they've told us at 3 p.m. is that the court actually closes at 4. And so according to what we've been told, that they want to give people an opportunity to go to the courthouse should they need to go to the courthouse. So this 24-hour time frame, which they have told us is something that they wanted us to really share with the public, because this is something that can be quite confusing, and knowing how much time you have to vacate is very important. So the ideal scenario is that the sheriff could actually come by and post a writ of possession on your door on Thursday at 3 p.m. This 24-hour start time actually begins on Friday at 12 a.m. And officially ends on Saturday at 12 a.m. However, because the Palm Beach County Sheriff's Office does not execute these on the weekends, you have actually until Monday early morning at the latest. However, if Monday is a court holiday, you actually have into the next non-holiday, which would most likely be a Tuesday, until the sheriff will return. Obviously, we live in an area with disaster response and hurricanes, so that also might, if the courthouse is closed, the sheriff's office would not execute. The likely scenario is that they come by on a Monday around 3 o'clock. Tuesday is that full 24 hours. And then Wednesday morning, the sheriff can come by to forcibly remove you if you haven't already moved, if necessary. So it's really important to keep that idea of mind of the 24 hours, because that's really important to knowing what you need to do for next steps. So what can I do? And there are a few options with my colleague Jacob will share with you.
Yes, so thank you, Anne-Marie. Like Anne-Marie mentioned, the big thing is that urgency is the key at this point. When you've had a writ of possession posted on your door, that time frame is ticking, and especially given, like in the example, if it's a Monday and you're served a writ of possession, it could be as early as Wednesday morning before the sheriff is actually there to execute on the writ. So there's limited time and limited options, but there are still some options. The first thing would be contact legal aid. We handle a lot of cases like this where we have a client call in or email and they've been served a writ of possession and they're not sure what to do. We're there to help them and to review the case with them and see if there's anything that we can assist with. More often than not, that will involve filing an emergency motion to the court. This is something that you can do as a tenant, and there are different resources that we will disseminate that can kind of give you a template for how to respond to this. But that said, these emergency motions, as I'll speak a little bit more about on the next slide, they're a lot of times they're kind of a long shot motion. So it's definitely important to make a plan, even if it's a temporary plan. You don't have anywhere to move into right away. You still need to make a plan and move your personal belongings, into storage if possible, or somewhere so that they're not just out on the street when the sheriff comes back to execute the writ. The possible legal actions to stop the writ of possession. The most common one is a motion to stay the writ of possession, an emergency motion. And a motion to stay the writ of possession is a formal request asking the court to stop the sheriff from executing the writ of possession. The motion must be filed with the clerk of court, and it's very important when filing the motion, if you go to the clerk's office to file this, or if you are able to do it online, the clerk should be advised that it is an emergency motion so that the clerk will transmit the motion to the court as soon as possible. As I mentioned before, it's important to know that it is extremely rare for the court to grant a stay. Generally, the inconvenience or difficulty to the tenant is not sufficient to grant the stay. We will have situations and clients where they do, write an emergency motion, and it's essentially saying like I have nowhere to go, or I wasn't ready to move yet, or I'm still in the process. And while we understand that those are completely legitimate concerns in the eyes of the law, that's typically not going to, in and of itself, enable you to a stay from the writ of possession. The court will only grant a stay in extreme circumstances that prevented a response to the lawsuit or other great irregularity or fraud on the court. An example of that would be, if there was some legal defense that the tenant was not aware of at the time, but does become available, you can include that in your emergency motion. For example, if there was an issue with the notice, if there was an issue with the complaint that your landlord filed, there needs to be some legal basis or legal justification for a judge to consider granting your emergency motion to stay the writ. The other one would be, sometimes if you get in touch with your landlord and you're trying to negotiate something, like perhaps a vacate date, for example, saying that I can move out in this amount of time. Sometimes you can include in these motions that you're in the process of reaching a settlement in the case. You're just not quite there yet. So there are a few different things, but the biggest thing to remember is that unfortunately, in these motions, just stating that you don't really have anywhere to go, something like that, that's typically not going to meet that legal threshold for the motion to be granted. Here's an example of a pro se emergency motion. Pro se just meaning that it's prepared by the tenant or defendant, him or herself, as opposed to by a lawyer. Here you can see it's pretty simple. You would just fill in, you can go on the clerk website, pull up your case, write in the correct plaintiff, usually the landlord or property management company or whoever it may be, and then yourself as a defendant. The case number and division number will be there on the online court docket. You just go to Palm Beach County Clerk of Court website. You can search the court records, put in your name, and your case should show up. And then the pro se defendant's emergency, again, very important to include that it's an emergency motion to stay the execution of the writ of possession. You just put in your name as the defendant, the property that's at issue, and then you state your grounds for requesting the stay. The other thing that I think is important to remember with these, it is oftentimes, I know I'm beating a dead horse, but it's imperative that once you get this writ of possession, the most important thing is to take some action. Because once the sheriff comes back to execute on the writ of possession and has already started removing things or changed the locks, typically it's going to be too late to enable you to get back into your apartment. So reach out to us. We will provide the information for how to complete the pro se emergency motion, like the one in the presentation I just pulled off of the internet. The templates are there for you if you need them, and just also request a hearing if possible, and then that way you have some time to prepare some sort of defense. But all in all, the process can move very quickly, and that's why urgency is very important. These writs of possessions are at the very end of the procedural life of the case. So, Maria, if you have anything else to add.
I think that was good, Jacob. I think exactly right that timing is of the essence.